Welcome to Las Vegas Business, Bankruptcy, and Construction Law Podcast.
Hello, everyone. Welcome to Las Vegas Business, Bankruptcy, and Construction Law Podcast, the podcast with attorney Tony May, where he unravels the complex landscapes of business bankruptcy and construction law. I'm your host, Sean O'Connor. Today, Tony is letting us in on how he manages construction claims for his Nevada clients. Everything from drafting bulletproof contracts and resolving mechanics liens to navigating Chapter 11 and other complex business litigation. Tony, good to see you.
Good to be here.
You know, you're one of the few attorneys in the U.S. with dual licensure as an attorney and a professional engineer. I'm wondering how your technical kind of boots on the ground experience as an engineer changes how you read a construction contract, compared to a traditional lawyer without that kind of experience.
So I guess one of the biggest things is having practiced as an engineer several years before I decided to quit everything and go to law school. I think it gives me a little bit better perspective of items to address. It gives me a perspective as to potential problems that could result going through the design process and submitting designs, getting them approved for projects. There's a knowledge there that I do believe as I look through a contract allows me to advise clients specifically on issues that should be addressed before the project starts through the analysis of the contract itself. And I do think it helps me and my clients get better prepared for an upcoming project. I will have sometimes I'll have clients call me and on a specific project and wanting to modify the scope of the contract, and I do use my engineering background and knowledge to kind of make sure that the contract looks into things and addresses potential issues that could arise before the contract starts, which I believe helps during the contract processes, so that we get ahead of the problems. The better my client understands the contract and what's required and included within the contract, as well as their liabilities, the better my clients are able to protect themselves during the course of the project and hopefully avoid litigation.
I'm thinking about the CMFA, right? Can you tell listeners about the most recent CMFA seminar and what insights you were able to gain?
So the CFMA is the Construction Financial Management Association, and I'm involved in the Nevada chapter, the Southern Nevada chapter of CFMA. I've been involved in it for a long time. I started out when I was first practicing when I graduated from law school in Iowa, and I went to work for a law firm in Iowa. They got me involved in this organization. It's a great organization. It basically focuses on the people that manage the money for the construction industry and helps them with their decisions on how to manage the projects. Recently, they had asked me to put together a seminar, so I did last month, and we kind of focused on the mechanics lien statutes and how the mechanics lien statutes differ from normal and ordinary accounting principles, and how not following procedures and following through on lien releases, lien waivers, and following the lien process correctly can result in problems on a project. I believe we're going to talk about this more later, but mechanics liens are very, very important for contractors within the state of Nevada and within the whole continental United States. It's a means that the legislatures in all 50 states have put together to allow contractors to get paid on projects, and it secures their payment if they follow the rules leading up to that. And so I merge the two accounting principles and as well as the lien statutes within the seminar to kind of give everyone a heads up at CFMA on what they needed to do to be better prepared to follow the procedures.
What are the most common reasons for filing a construction claim in Nevada? And do you see more of one versus another?
So prior to 2015, probably the biggest thing by far was the construction defect litigation. In Nevada, I think it had one of the highest rates in the nation of construction defect claims. the statutes that allowed Chapter 40 were extremely, I guess you could argue they were kind of lopsided in the homeowner's interest. There was just tons and tons of litigation. In 2015, the Nevada legislature, seeing that it was causing a lot of problems for contractors to get insurance, as well as to survive, in the construction industry here, they made some major changes to the Chapter 40 rules and laws. And then a couple of years later, they came back and put some of the changes back. And since then, Nevada's gone from probably one of the highest rate of construction defect cases per capita or per home to more of, I think, a reasonable number. But there are still all construction defect claims in Nevada. I'm dealing with a few, and my firm represents both the homeowners sometimes and the contractors, depending on who our client is, which I think gives us a pretty good advantage with those type of claims, because we work on both sides both sides of the fence, for lack of a better way of saying it. So we understand, where the contractors are coming through, and we also understand where the homeowners are coming through. In addition to that, there's mechanics lien statute claims, there's stop work notices claims, there's breach of contract claims, there's unjust enrichment claims. So there's a variety of other types of claims in the construction industry that focus on, either getting paid. It focuses on disputes with change orders. Construction projects almost always have some change orders. Some contracts and projects have a significant amount, which a lot of times results in problems, between the owners and the contractors about payment and disputes that arise from that. So there's a myriad of different claims that come up. Right now, probably the biggest thing that I'm dealing with, I represent both homeowners and contractors with regard to the Nevada State Contractors Board, and there seems to be a lot of things going on with that, just because of the Nevada legislature keeps adding statutes that control contractors and what they're supposed to do under different circumstances, such as whether you have a residential or commercial contract. There's a bunch of different rules that contractors have to abide by.
Well, for contractors now in 2026, what is the deadline in the state for recording a mechanics lien?
So in general, I'm gonna kind of explain it. I'm gonna tell you a war story. In general, you have 90 days from the date of completion of the work, and the statute basically says it's 90 days from the last day of work, last day of providing labor, or last day of providing materials, and it's supposed to be the latest of all three. And generally speaking, if you're a subcontractor, let's say you're a grading subcontractor on a project, you can come and grade the project, and then a year later, when the project completes, if you don't get paid your retention or any other amounts, you can record your lien against the property, because the latest of everything combined would be the latest when the project's completed. However, I recently had a case in front of a judge in Nevada, and the judge admittedly didn't have any understanding of construction law. But that judge invalidated one of my client's liens, even though they recorded their lien within the time frame on a commercial project, within the 90 days of completion of the project, but it was more than 90 days from the last time they provided services. And the court negated and invalidated the lien. And unfortunately, because the amount in question, the disputed amount, was not significant enough, my client decided not to appeal the decision, which was in their best interest not to appeal it. But it frustrated me quite a bit when the judge, I believe, interpreted the statute completely incorrectly and invalidated construction issues that are important for contractors in the construction industry regarding payment process and how payments get made and decided upon over the course of a project.
That's an area where, like you said, the judge, wasn't up to speed or, necessarily expert on some of the statutes. So you lost that ruling. But I'm wondering what happens if you miss the deadline sort of your own volition?
There's two parts to that. So the Nevada mechanics lien statutes, there's case law that talks about that they're strictly construed, and then there's case law that talks about substantial compliance. The courts appear to be and continue to be strictly construing deadlines. For instance, if you have 90 days to record your lien and you try to record it on the 91st day, then generally speaking, it's strictly construed and your lien is invalid because you missed the date. If you provide notices and the notices aren't fully, completely correct or don't have all the information that is required by the notice, then the courts seem to, they traditionally go to the substantial completion, and they look in to see whether or not the homeowner or the owner of the project is prejudiced in any way, and if they had knowledge or if they could have gotten knowledge a different way, then the courts usually allow it to continue. So it's kind of depending on what went wrong, whether or not it's strictly construed or whether or not it's substantial compliance.
I know in 2024 and 2025, regulations like AB 39 and RO 32-24 have updated definitions for repairs and informational forms for liens. So how should small contractors adjust their daily paperwork to stay compliant with the Nevada State Contractors Board? Any tips there?
Yeah, I mean, if you are a contractor in the state of Nevada and you're providing any services, general contractor specifically, to residential construction, any home, then you need to pay strict attention to this. The AB 39, the most recent statute, it was, I think, made effective in October of 2023. And that statute has the very, very last statute within Chapter 624 was added, and it has a ton of requirements that are required. And if you're a contractor doing residential construction in the state of Nevada, there's one of the rules that it's added is you can only get 10% or $1,000 as a deposit for the contract. That's it. If you get any more, then the contract potentially becomes voidable on behalf of the homeowner. Voidable means the homeowner, if they want to negate the contract, they can. There's also a myriad of other requirements stating, for instance, that the contractor for residential construction has to provide an estimated completion date of the project. And a lot of, smaller contractors, they don't do that. A lot of smaller contractors typically would get 20, 30, 40% down so that they could purchase all of the materials, which, if you're a small contractor, is a huge benefit in order to keep the prices down, because you give a bid on a project for, let's say, that has framing and concrete. You got to do the concrete first. You got to wait till the concrete's done, and then you get the framing. If you buy it all at once, then you know what the prices are. You know what you're into. If you have to buy it in pieces because of the contractors board's forcing you to do it a certain way, then the material costs could escalate significantly. I mean, everybody knows today, who's been following the news in any way, that we have tariff issues. We have all kinds of, back and forth with different countries, which can significantly increase the cost of a specific item. During COVID, there was big problems with getting lumber, steel, equipment. Pretty much, I had a client that took him a while to get some electrical components for his project, stuff that's normally, there whenever. So you just never know when that happens. So it's made it more difficult for contractors, but they need to be very, very clear that they look through that statute. It's NRS 624.970. And there's a whole lot of stuff in there. They have to provide lien releases. There's a whole bunch of stuff that if they don't do can get them in trouble with the contractors board. And it allows the homeowner to actually step in and modify the contract after the contract has been introduced. And as long as it's deemed reasonable, then the contractor is going to be at the mercy of the homeowner. Now, the regulation you were talking about is, I think the contractors board updated there's one of the general requirements that a general contractor has to do is, whenever they have a contract with a residential construction homeowner, they have to provide to the homeowner the information about the recovery fund, the Nevada State Contractors Board Recovery Fund, which allows homeowners to get up to $40,000 under certain circumstances if a contractor is found to have done things and get sanctioned, and the contractors board determines that there's damages that relate to that, they can get up to $40,000. They also have to provide a specific notice to all homeowners for residential construction about the lien rights and what they can and can't do. It tells them they need to make sure that the contractor's licensed. They have a right to have an attorney. They have a right to get a bond. So there's a bunch of stuff that the Contractors Board requires to be put in those contracts. Now, if you're a commercial contractor doing commercial projects, none of that stuff applies to you. I think they deem that as if you're a business, you need to be sophisticated and take care of yourself. But with regard to homeowners, it's a completely different story with the requirements in Chapter 624.
So you mentioned with some of the new regulation and its impact on negotiating or just handling the price volatility. And I know we've only got a couple of minutes here, Tony, but in this era where material costs and supply chain volatility, how does a contractor cover themselves? Is there a specific language they should include in their bids to account for sudden price spikes or what might be considered inexcusable delays?
So I would definitely caution all construction or contractors in the state of Nevada, if they have an attorney, they should sit down with their attorney and go over. There's a bunch of different ways you can address that. You can actually put escalation clauses within the contract that say that the price is based on the current amount and that price only lasts for a certain period of time. A lot of proposals will say that this bid amount or this is only good for 30 days or 20 days. But once you enter into the contract, that's usually when the problem hits, because you go into it 4 or 5 months and then there's that huge spike. And now all of a sudden your project that was a good, you're going to make some good money off of it. All of a sudden now you're going to lose on it. And if you're obligated to continue, but if you put in price escalating clauses, force majeure clauses, where you're basically saying under certain circumstances, tariffs, war, different things, that it gives the contractor the ability to go in and look at the new prices and then go to the homeowners as a change order pursuant to the contract. The homeowner is going to fight the contractor on that, obviously, because they don't want to pay a significant amount more than what the contract originally was or that included. But contractors can go through and add various different types of provisions within the contract to give them the ability under those circumstances to step in and modify the prices. Or they could just do a cost plus contract where they say whatever the cost is plus, my overhead and profit, 20 to 40%, depending on what the contractor is. And then basically it's whatever the cost is, they just bill it right to the homeowner or the owner of the commercial project. And then it's just, they add their cost to it and move forward. That's the simplest way to do it. But most business owners or homeowners don't want that type of a contract. They want to know going into it what it's going to be.
No, that makes sense. And by obviously an advantage of putting it into the contract up front that this could happen, just sort of sets gives them a heads up that, there could be an issue, and we'll talk about it if it comes up. Well, we're out of time, Tony. Great to see you. Great to talk to you.
It was a pleasure being able to go through this process.
Thank you for listening to Las Vegas Business Bankruptcy and Construction Law Podcast. Whether you're a developer, a contractor, or a business owner looking for a way forward, visit their website, maybrocklaw.com, for more information. We hope you found this episode helpful. Do us a favor, like it, leave a review, subscribe, or share a link with a colleague. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.